Welcome back to Making a Murder My Journal, and today we're going to jump right in to Mrs. Zellner's response to the state of Wisconsin, February 1st, 2019. State of Wisconsin Court of Appeal District 2, State of Wisconsin versus Steve Avery. Date, February 1, 2019. Clerk of Courts of Wisconsin. Defendant appellate's reply to the state's response in opposition to Avery's motion to stay the appeal and remand the cause to the circuit court. Now comes defendant appellate Steve A. Avery, through his attorneys Kathleen T. Zellner and Stephen G. Richards, for his reply to the state's response in opposition to his motion to stay the appeal and remand the cause to the circuit court, states as follows. Introduction. The state's response conveys an attitude of impunity for its past actions of withholding exculpatory evidence and its current action of continuing the concealment of its destruction of potentially exculpatory and useful evidence. When the state disclosed a CD of violent porn from the Dassey Yonda computer 12 years after the CD was created and concealed from prior counsel, the state argued, as it does now, that Mr. Avery was attempting to add new material to his 974.06 motion. The court did not accept the disingenuous response then, and it should not now accept the state's current disingenuous response, which echoes the same argument. The state wants this court to overlook the undisputed fact that 2 weeks ago, on December 28, 2018, when it filed its response to Mr. Avery's request for new DNA testing of the bones from the Manitowoc gravel pit, it never once admitted or disclosed that it had given the bones back to the Halbach family in 2011 without notice to Mr. Avery or his counsel. Plaintiff respondent's response in opposition to the petition to stay the appeal and remand this case to the circuit court, December 28, 2018, page 1 through 8. Instead, the state carried on its charade of concealment by claiming that Mr. Avery could voluntarily dismiss his pending appeal. The state's response specifically stated, the state notes that Avery has the option to voluntarily dismiss this appeal if he wishes to litigate a Wisconsin Statute 974.07 motion now, if he chooses to do so, and if the circuit court grants DNA testing that produces exculpatory results, it is possible that some or all of the issues raised in Avery's Wisconsin Statute 974.06 filings will become moot. Alternatively, if Avery is not confident that his Wisconsin Statute 974.07 motion will be successful, or not confident that testing will produce exculpatory results, he should wait and see if he prevails on appeal, and then decide if it is necessary to litigate a Wisconsin 974.07 motion. The MOVAC can bring a Wisconsin Statute 974.07 motion at any time after conviction or adjunction. What the state fails to mention in its helpful guidance to Mr. Avery is that it facilitated the destruction in 2011 of the very evidence that Mr. Avery would be hoping to test if he was so foolish as to voluntarily dismiss his current appeal. The state has not been prejudiced in any way by the delays granted to Mr. Avery as a result of the state's misconduct in withholding and facilitating the destruction of material evidence. The state wants the court to turn a blind eye to these actions and focus instead on Mr. Avery's action in seeking a second delay in filing his brief. Given that this case spans 12 years post-trial, the request of an inmate serving a life sentence without parole and seeking 2 delays based on recently discovered, suppressed, and destroyed evidence hardly constitutes a threat to the orderly administration of justice in the state of Wisconsin. If Mr. Avery waited to raise his current claim until after his appeal was concluded, the state would undoubtedly argue that he has failed to show a sufficient reason for not raising the issue sooner. As a result of the state's action in concealing and withholding the Dassey Yonda CD and concealing the return of the bones to the Halbach family, Mr. Avery has been forced to delay his appeal, and therefore his quest for a new trial and eventual freedom. 1. Mr. Avery's motions are not dilatory. The state, in its response to Mr. Avery's motion to stay the appeal and remand the cause, suggests that Mr. Avery's motion to remand for further proceedings are intended to perpetually delay this appeal. This suggests it's believed by the record, including the instant motion. Mr. Avery has pursued 2 motions to stay the appeal and remand for further proceedings and 1 motion to supplement the record, on which this court ordered proceedings in the circuit court. Mr. Avery maintains that each of these motions raised meritorious claims for relief based upon issues relating to his original 974.06 motion and supplements. Indeed, Mr. Avery has not filed these motions to delay this court or unduly postpone his appeal. Instead, Mr. Avery has filed his motions to apprise the court of ongoing due process and discover violations that, only after months of litigating Mr. Avery's post-conviction motion and its appeal, have recently been discovered. These motions are not intended for delay. 2. This motion for stay and remand is analogous to Mr. Avery's previous motion to supplement the record in connection with an alleged due process violation. Mr. Avery has previously moved this court for a remand to the circuit court to litigate motions to supplement the record with a previously withheld CD containing unique, violent pornographic search material from the DASIC computer. 5/15/2018, Defendant Appellate's motion to supplement the record on appeal. In that motion, Mr. Avery asked this court for leave to supplement his 974.06 motion with the content of the CD containing the results of a forensic examination of the DASIC computer. Neither the CD nor its content had ever been produced to Mr. Avery of his defense team at any stage of his criminal proceedings. In that instance, this court retained jurisdiction but remanded the case to the circuit court for Mr. Avery to file a supplemental post-conviction motion, 6/7/2018, appellate court order at 2, because Mr. Avery's allegations relate to issues already raised in the underlying record. See Issue 3, Infra. The same outcome is appropriate here. 3. Because the court originally remanded for scientific testing so that the test results could be included in Mr. Avery's 974.06 motion, the state was on notice that Mr. Avery intended to test the suspected human pelvic bones recovered from the Maddox County gravel pit. Mr. Avery's 2015 appeal concluded on September 8, 2016. When this court remanded the case to the circuit court for post-conviction scientific testing of evidence. Among the evidence Mr. Avery asked the circuit court to test were the suspected human pelvic bones collected in the Manitowoc County gravel pit under Calumet County property number 8675. Therefore, the state has been on notice that Mr. Avery wished to obtain the Manitowoc County gravel pit bones for several years. The state fails to acknowledge that Mr. Avery is appealing the circuit court's error in abusing its discretion in denying Mr. Avery's motion to vacate its October 3, 2017 order and allowing additional scientific testing. Moreover, the Manitowoc County gravel pit bones were the subject of the September 18, 2017 agreement, wherein the parties agreed to further scientific testing. Thus, the state's claim that the instant motion is devoid of foundation in the record is spicious. Mr. Avery has been petitioning the circuit court, for testing of the Manitowoc County gravel pit bones for years. With such a foundation in the record on appeal, the state's response in opposition to Mr. Avery's motion should be denied. 4. The state should not benefit from concealing a report, failing to give notice, and facilitating the destruction of biological evidence. The state's opposition to Mr. Avery's motion is tantamount to asking this court to sanction a rule where prosecutor may hide, defendant must seek. Banks versus Dretke, 540 U.S. 668-696, 2004. Such a rule is not tenable in a system constitutionally bound to accord defendants due process. After all, the state, in its response to Mr. Avery's motion, makes no effort to deny the due process violations Mr. Avery alleges, i.e., that the state concealed a police report, failed to give statutorily mandated notice to Mr. Avery and his attorneys of its intent to destroy biological evidence, then facilitated the destruction of the same evidence. The state should not now reap the benefit of its past statutory and due process violations. Such an outcome would contravene the sense of basic fairness inherent in our justice system. 5. Conclusion. Wherefore, undersigned counsel respectfully requests that this court enter an order staying this appeal and remanding the cause to the circuit court for proceeding to determine whether the state has violated Wisconsin Statute 968.205 in Youngblood versus Arizona. Dated this first day of February 2019, respectfully submitted, Kathleen T. Zellner, admitted pro hac vice, and Stephen G. Richards. So in a quick summary, we can tell that Mrs. Zellner is not pleased with this response from the state. First of all, she's explaining that there is no accountability being held for this, and that she is saying that the original 974.06 motion is stating that it pertains to all of this. So how are they calling it new? She's basically saying to deny the state's request to keep this separated, and we will go from there. So I appreciate all of you guys so much. Please go ahead, hit that like button if you enjoyed the video. If you would like to stay updated, hit that subscribe or even the bell itself. So with that, it's going to be a short one today. So if you didn't do the crime, you shouldn't sit the time. Thank you.